And a good Sunday evening to you, everybody. Welcome to Bethea'S Byte Reloaded. I'm Ernest Bethea, the last outlaw. Welcome to the drama-free true crime destination. We are going to go ahead and get things started off with a developing story coming out of Florida right now. Earlier this evening, I reposted a missing persons post from Duchess on YouTube. Shout out to Duchess. That a 4-year-old girl was missing and an Amber Alert was set off. The Amber Alert was issued for Serafina Gingles, last seen wearing light-colored clothing, and her mother, Mary Gingles, 34 years of age, who was last seen wearing an orange flower shirt and tan shorts. Last seen in the 5800 block of Plum Bay Parkway in Tamarack, Florida. They said that they might have been in the company of Nathan Gingles, who was last seen wearing all black. They may have been traveling in a 2016 silver BMW X3 SUV with Texas plates 5DV2950. Well, I have some good news and some bad news to share with you all. If you'll bear with me one moment. This is the report I'm getting from CBS 12 in Broward County, Florida. Deputies provided a second update regarding a missing 4-year-old girl, confirming that her mother was shot and killed near the scene. Deputies say 34-year-old Mary Gingles was shot and killed inside a home on the 5800 block of Plum Bay Parkway in Tamarack. The suspect, 43-year-old Nathan Gingles, was located with only the child this morning around 11 a.m. in North Lauderdale. That's according to an update from the sheriff. Nathan has been arrested for violating an injunction regarding no contact with the child and her mother, per the Broward County Sheriff's Office. The original Amber Alert was triggered after deputies responded to a shooting early Sunday at the 5700 block of Plum Bay Parkway in Tamarack. They found an unidentified man suffering a deadly gunshot wound at the scene, and it was later discovered that that 4-year-old Serafina Gingles and her mother had been taken from the location. At this time, the investigation remains active and ongoing, and deputies urge anyone with information on this incident. You are being asked to contact the Broward County Sheriff's Office by way of their Crime Stoppers number. That number is 954-493-TIPS. Again, Broward County Crime Stoppers at 954-493-8477. You can remain anonymous. But let's get this 4-year-old Serafina Gingles and 34-year-old Mary Gingles the justice they so richly deserve. Alright. Now, I've got a lineup for this week, and it is crazy right now. Now, in fact, I've even taken a line from an old song and put a little added twist to it. The song says it's a thin line between love and hate. In this case, it's a thin line between love and murder. We're going to kick things off with the beginning of a new trial that's going on right now. It's called the Rose Petal Murder Trial. South Carolina versus Zachary Hughes. Hughes is accused of murdering Christina Parcell, who was stabbed 31 times and found with rose petals scattered around her. Let's take a look and see what we're working with here. Okay. The case is out of Greenville, South Carolina. A concert pianist known for memorizing Beethoven's sonatas is standing trial on charges he brutally murdered a woman whose body was found surrounded by rose petals. Zachary Hughes, who you see right here on your screen, is charged with murder and possession of a weapon during the commission of a violent crime in the death of Christina Parcell. Parcell was stabbed approximately 31 times in her home on October 13, 2021. At the time of his arrest, police said Hughes, a Juilliard-trained pianist, had no criminal history. Investigators linked Hughes to Parcell through Hughes' friend, John Mello. At the time of Parcell's death, she was in a custody battle with Mello over their shared daughter, and Mello was facing charges of custodial interference for taking the child out of the country. The charges against Mello were dismissed in April of 2024. Prosecutors say they found approximately 1,769 WhatsApp messages sent between Hughes and Mello, including one where Mello asked the defendant to harass Parcell. Additional evidence against Hughes includes a ring video showing a person leaving Parcell's home and riding a bicycle out of the neighborhood. A search warrant revealed a bike matching that in the video at Hughes' home. Hughes' defense has maintained his innocence and has instead pointed at Parcell's fiancé, Bradley Post, as a potential suspect. Post, who called 911 after finding Parcell's body, is not charged in her death, but he is facing charges of sexual exploitation of a minor and buggery in a separate case. Now, we're already 4 days deep into the trial. And as of the last day of the trial, which was this past Friday, Valentine's Day, how appropriate. Here's what happened. Sergeant Jared Sparkman returned to the witness stand and said that Bradley Post was deleting photos from his phone while waiting for police to arrive and maintained possession of the phone until October 19th. Sparkman confirmed no lineups were done because no witnesses said they saw the face of the man leaving Parcell's home. Greenville County Medical Examiner Dr. Claire Rose described 35 sharp force injuries to Christina Parcell's body. Among the injuries were stab wounds that perforated Parcell's lung, as well as her carotid and jugular arteries. An analyst, Tim Nafzinger, testified that DNA found under Christina Parcell's fingernails on her right hand was 825 million times more likely to belong to Zachary Hughes than anyone else. I'm going to assume that tomorrow being President's Day, this trial will pick up on Tuesday, and I'll have more details as it comes along. But honestly though, 31 stab wounds, honestly, I'll call that overkill. And I will call that overkill any day of the week, twice on Sunday. Next up, Donna Adelson, when we last heard from her, was in protective custody. She claims she was attacked in jail. She reported a fellow inmate assaulted her in conjunction with an attempt to extort her. Let's see what Donna Adelson's talking about here. Because this is one of those cases that gets uglier and uglier by the day. Dateline, Tallahassee, Florida. The elderly Florida woman awaiting trial for the murder of her former son-in-law has been moved to protective custody. Donna Adelson reported that a fellow inmate assaulted her in conjunction with an attempt to extort her. Shonda Knight, the executive director of community and media relations for the Leon County Sheriff's Office, told Court TV, quote, "I can confirm that Mrs. Adelson is currently in protective custody as a result of her complaint," end quote. According to Knight, 75-year-old Adelson reported on February 3rd that another inmate had grabbed her by the arm in the bathroom area of the Leon County Detention Facility back in December. Court TV has obtained a copy of a motion for an Arthur hearing, which Donna filed last Friday, February 7th, my birthday. An Arthur hearing is a legal proceeding unique to Florida in which a defendant accused of a non-bondable offense can petition the judge to set out bail despite the severity of their alleged crimes. The filing details reasons why Donna believes she should be released while awaiting trial. It provides a window into her day-to-day life in jail, details her health concerns, and gives more insight into the abuse she's allegedly been subjected to at the hands of other inmates. In the motion, lawyers cite their client's advanced age, coupled with lack of sleep and the harsh conditions of confinement. They also state that medical personnel at the Leon County Detention Facility are not equipped to handle other health concerns, such as hearing problems. They say she was under the care of an ENT prior to incarceration and regularly needs her ears cleaned out with special equipment that the jail doesn't have. They also say that the detention facility cannot properly treat pre-existing pain in Donna's back and legs. In addition, the motion details Donna's struggle to breathe. Her lawyers have noted that her labored breathing makes it difficult to hear over the phone. The filing also states that on February 1st, Donna sustained a deep gash after bumping into a washing machine after cutting herself on a rusted metal bar. A visit to the nurse didn't get her so much as a Band-Aid. She finally made it to a medical facility on February 3rd, when the wound was properly cleaned and she received a tetanus shot. Physical abuse Donna endured allegedly began with an attack by a fellow inmate in the shower. Donna thought she was alone when she suddenly felt a hand run up her spine. In another instance, an inmate slammed Donna from behind, knocking her into the frame of her bunk bed. According to records, the most frightening incident happened on October 7, 2024. Donna was leaning on a sink brushing her teeth when her arm was violently jerked by a much larger inmate who demanded Donna get canteen items for her. The aggressor apparently instructed Donna on what she wanted from canteen on a weekly basis. Donna's husband, Harvey Adelson, had to order the canteen packages on her behalf. Donna's attorneys say Harvey has spent $1,150 on canteen for the aggressor alone. Donna had stayed silent about her health woes and threats she received until that February 3rd visit to the jail's medical facility. She opened up to the physician's assistant about being attacked by a fellow inmate. Unbeknownst to Donna, the medical unit reported the attack, which led to her being placed in solitary confinement. Adelson allegedly hatched a plan that led to the 2014 murder for hire of Dan Markle, who was gunned down on July 18, 2014, while pulling into his own garage. Markle, a Florida State University law professor, was in the middle of a bitter custody fight at the time of his death. Donna brought her Ferrari-driving periodontist son, Charlie Adelson, into the fold. He, in turn, arranged for hitmen to kill Markle. Donna was taken into custody on November 13, 2023, exactly 1 week after Charlie was convicted. She was apprehended at Miami International Airport while trying to board a flight to Vietnam via Dubai on a one-way ticket. Donna, who is charged with first-degree murder, conspiracy, and solicitation, is set to face trial in June. Donna's next court date is a case management hearing set for tomorrow, which is set for February 11, and Court TV will be covering the proceedings in addition to a motions hearing scheduled for February 26th. The case management hearing has already happened, and the motions hearing is set for the 26th. Now, like I said, is this case is crazier and crazier by the day. Now, Donna Adelson is in protective custody because because of an attack on her person, and now basically she has to pretty much wait in solitary confinement. Will she get her bail? We'll just have to wait and see. We'll have to wait and see what becomes of it next. Curiouser and curiouser, like someone once said. Alright, next up. A murdered lawyer had pink fingernails stuck to chest, and the suspect is identified as a former ballerina and computer scientist. Oh, and by the way, I know I once tell you this during a quote unquote cleanup session that all the articles you get from me, well, some of them start right here with at the original True Crime Obsession Court TV, but also as part of my policy of no gimmicks, no drama, and no BS. I went back to an old friend of mine and started getting a lot of my articles from the crime section at People Magazine. So now I got both bases covered. Now let's go to this article. A murdered lawyer had pink fingernails stuck to chest, and the suspect is identified as a former ballerina and computer scientist, according to a report. Joseph Donahue was found dead on a houseboat after his family requested a welfare check on him. This is Joseph Donahue, and this is our suspect here, Nora Nelson. Here's the breakdown. The 65-year-old Boston attorney found dead on his houseboat this month was discovered with pink fingernails stuck to his chest, according to authorities. Joseph Donahue was found slain on a houseboat in a marina in Boston on February 2nd by officers responding to a welfare check from a family member. That's according to the Suffolk County's District Attorney's Office. Boston police have charged 24-year-old Nora Nelson, who was on the houseboat when police arrived, with murder. This is what the department said in a statement. Upon arriving at the scene, responding officers encountered Nelson with her dog, but when they tried to confront her, she allegedly tried to stop them from entering the houseboat. Police wrote this in a report filed in court and cited by the Boston Globe. After officers managed to get inside the boat, they found Donahue's body wrapped in a tarp and duct tape attached to weights. That's according to the investigators, the Boston Globe, NBC Boston, and WCVB. Donahue had artificial pink fingernails stuck on his chest when he was discovered, according to the report from the Boston Globe and CBS News. There were blood stains on the blanket covering his body as well as the rear of the houseboat, according to police. Another dog was also found floating dead in the water. According to the police report cited by the Boston Globe. Nelson was arraigned in court according to the Boston Globe, WCVB, and CBS News. Prosecutors contend Nelson tried to mislead police during their initial conversation, giving a fake name and claiming she hadn't seen Donahue in some time. Again, CBS News, the Boston Globe, and WCVB reported this. She also allegedly claimed falsely that the blood on the vessel was from her period. Again, that's according to prosecutors, to a report by the Boston Globe. Her statements were contradictory, and frankly, she lied, prosecutors said at her arraignment. According to her social media profiles, Nelson is a graduate of the University of Maryland, a former ballerina, and describes herself as an entrepreneur and a farmer. In a photo on her Facebook from 2020, she wrote, "I've been out of the ballet scene for a while, but I think I still got it." End quote. Donahue was an attorney in Boston and divorced father of three. Borghesani told People he dedicated his life and career to helping others. That's what his family previously said to Boston 25. "Our family is heartbroken by this unimaginable loss. Joe was a wonderful family member, a cherished friend, and a trusted colleague," they said. "He is loved and will be deeply missed." Nelson entered a plea of not guilty in court, and she is being held without bail. And that's according to reports from the Boston Globe, WCVB, and CBS News. Somewhere, somehow, some way, I got a feeling the one thing they haven't mentioned in that whole entire report was money. And if I had to hazard a guess, I would say somewhere money is involved. It's not showing it. It's not showing off right off the top of the hat. But I got a feeling money is somewhere involved in this. And once it comes out, your motive will be right there. Now let's get ready to move on to this next story. I like this. This is a Justice Serve. This one's going straight to the Justice Serve file. 3 men convicted of luring men from a New York City gay bars, robbing them and leaving them for dead. 37-year-old Jaquan Hamilton, 36-year-old Robert DeMeo, and 32-year-old Jacob Barrasso, all convicted of at least one murder after the deaths of Julio Ramirez and John Umberger. Alright, here's a dual pick of 2 of those victims. This is John Umberger on your left and Julio Ramirez on your right. 3 men accused of luring men from New York City gay bars, drugging them and robbing them, have been convicted of 2 murders. 25-year-old Julio Ramirez and 33-year-old John Umberger both died after being drugged within months of each other in 2022, according to prosecutors. Several other victims were drugged and robbed but survived their encounters. 3 suspects, 37-year-old Jaquan Hamilton, 36-year-old Robert DeMeo, and 32-year-old Jacob Barrasso, were convicted on all counts following a trial in New York court. DeMeo and Hamilton were convicted of murdering both Ramirez and Umberger, while DeMeo was convicted of only Ramirez's murder. All 3 men were also convicted of various robbery charges. Manhattan District Attorney Alvin Bragg said in a statement, "These defendants were motivated by greed, and their callous behavior left 2 men dead. I know the families who lost their loved ones are still suffering from so much pain, and I hope this verdict can provide at least some measure of comfort." Prosecutors said Umberger was found dead in his Manhattan apartment in June 2022, while Ramirez was reportedly left for dead in a taxi in April. Authorities said the men died from a combination of cocaine, fentanyl, and other drugs, according to the New York Times. The Manhattan DA's office said Hamilton, DeMeo, and Barrasso targeted Ramirez, a social worker, outside the Ritz bar in the Hell's Kitchen neighborhood of Manhattan. The men used fentanyl to drug the 25-year-old before transferring money from his accounts, which the defendants used to buy thousands of dollars in sneakers and clothes, according to prosecutors. Umberger was targeted in June outside the QNYC, also in Hell's Kitchen. He was drugged before being taken back to his apartment by the defendants, who then robbed him of over $2,000 and left him lying incapacitated on his bed, according to prosecutors. The trio were also implicated in the cases of other men who were drugged and robbed, as were two other defendants, Shane Hoskins and Andre Butts, who previously pleaded guilty. Hamilton, DeMeo, and Barroso could face the rest of their lives in prison following their convictions. So we don't have the sentencing yet, but I'm gonna keep an eye out for this. But as far as I'm concerned, they've already got 3 convicted and 2 more pleading guilty. Absolutely, justice served. And next up, we have a Florida man who allegedly lied about girlfriend's location has been arrested for her brutal murder. And that's according to local authorities. "48-year-old Stacey Ann Powell was reported missing 2 days after she last logged into her work computer. Here's your breakdown. A Florida man has been arrested for the brutal killing of his girlfriend at their home. 46-year-old Andrew Ridgway is facing charges of second-degree murder and providing false information to law enforcement in connection with the death of 48-year-old Stacey Ann Powell, who was reported missing 2 days after she last logged into her work computer, according to Auburndale, Florida police in a press release. Officers went to Powell's home on Thursday, February 6th to check on her and spoke to a handyman who had been hired to repair and remodel cabinets. I'm going to take you guys now to a report from Fox 13 in Florida.
Police say that a boyfriend will face charges for what they call a brutal and savage murder.
It all started with a missing persons investigation. This was yesterday. Auburndale police tell us 48-year-old Stacey Powell didn't log onto her work computer for 2 days, and they discovered her body at her home along Elaria Court at the estates of Auburndale. Her boyfriend, 46-year-old Andrew Ridgway, was arrested in Augusta, Georgia. He was driving her pickup truck. The police chief says he lied about his and Powell's whereabouts, saying that he was in North Carolina with Powell's grandmother.
And on February 5th, Stacey had taken an Uber from the residence to the Orlando airport to fly to Jamaica and didn't know when she would be back because she was visiting an ill father. Stacey's father lives in North Carolina, not Jamaica, and the grandmother lives here in Auburndale and was here in Auburndale.
Ridgway is charged with making a false report to law enforcement, and police will be seeking a warrant for homicide.
Well,
The article continues that the handyman reported that Powell and Ridgway were not home. While officers were talking to the handyman, Ridgway allegedly called the handyman to ask why the police were there. He apparently had security cameras that he could see that we were there. The police chief Terry Stone said at a press conference about the killing, according to WFLA. Again, here's a photo of the victim, Stacey Ann Powell. During a phone conversation with the officer, Ridgway said he was in North Carolina with Stacey's grandmother. He also allegedly told the officer that Powell had taken an Uber to Orlando International Airport on Wednesday, February 5th, and took a flight to Jamaica, as you just heard, to visit her father, who had been ill. We were quickly able to identify that Ridgway was not telling the truth about his whereabouts. The grandmother's whereabouts and Stacey's whereabouts, Stone said. Additionally, Stacey's father lives in North Carolina, not Jamaica, and the grandmother lives here in Auburndale and was here in Auburndale last evening. Officers executed a search warrant on February 6th and discovered that Stacey Ann Powell had been brutally and savagely attacked and murdered, Stone said. It was a brutal attack, Stone continued, so much that we had to wait till this afternoon to get identification on her because we recovered her body Thursday evening. Stone said not one, not two, but 3 crime scene technicians were needed to process the scene. Stone said investigators suspect that Powell was killed in the late afternoon or early evening of February 4th. Ridgway was apprehended in Georgia while driving Powell's Dodge Ram pickup truck the following day, according to Stone. He is now waiting extradition back to Florida, according to Auburndale police. And while the investigation is still going, you're asked if you have any additional information. You're encouraged to contact the Auburndale Police Department. That number is 863-965-5555. 863-96 all fives. If you any information you have will be very helpful to this case. As for Andrew Ridgway, who knows what could have been on his mind that would lead him to kill Stacey Ann Powell. But let's hope they get down to business and we can get justice for Stacey. All right. ASAP Rocky decided he would not take the stand in his assault trial over two felony counts of assault with a semi-automatic weapon. Not only did he not take the stand, we've already went through closing arguments. The 36-year-old hip-hop star said, "Absolutely, Your Honor," when asked by Superior Court Judge Mark Arnold if he had discussed the issue with his lawyers, and said he would invoke his Fifth Amendment right to silence. "I want my right to not testify," Rocky said. The prosecution may call one more rebuttal witness, and then the closing arguments at the 3-week trial will be on Thursday, which already happened. Let me dip in because I have more update. I have another update on that, which I will bring to you in moments. First, Massachusetts court denies Karen Reed's appeal to drop the charges. Her defense has argued for Massachusetts highest court to dismiss the most serious charges against her ahead of her retrial. Here's another ugly case that gets uglier and uglier by the day. Karen Reed will face the same charges, including second-degree murder, when she stands trial for a second time this spring after the state's highest court denied her bid to toss the charges. Prosecutors have accused Reed of hitting her boyfriend, Boston police officer John O'Keefe, with her SUV and leaving him to die in the snow outside of a friend's house. Reed has maintained her innocence, and her defense has alleged a wide-ranging cover-up at the hands of investigators and the owners of the home where O'Keefe's body was found. Reed's first trial ended in a mistrial after jurors reported they were hopelessly deadlocked. In the days after the trial, Reed's defense filed motions saying jurors had contacted them to report that they had in fact been unanimous that Reed had been not guilty of second-degree murder, and the panel was only split on the lesser charges. In their appearance before Massachusetts highest court, Reed's attorneys argued that retrying Reed on the murder charges would amount to double jeopardy. Her defense said they were contacted by 5 jurors after the trial and argued that the affidavits from the jurors reflect a clear and unambiguous decision that Ms. Reed is not guilty. Prosecutors argued that the jury's notes stated 3 times that it was deadlocked and never indicated that it had reached a unanimous ruling on any charge. However, the Commonwealth conceded that it too had been contacted by jurors who said that the jury had voted not guilty on at least 1 count. In its decision, the Massachusetts Supreme Judicial Court found there was no absence of discretion in trial judge Beverly Canone's decision to declare a mistrial. The court also found that the jury's 3rd and final note implied that they were deadlocked on all charges, not just some. That note stated in part, some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The justices found that Judge Canone inquired whether the jury had reached a partial verdict. Reed would have had standing to argue that any verdict was the result of coercive intrusion. Reed's retrial is scheduled to begin on April 1st. Her attorneys have indicated they plan to file another motion to dismiss the case in its entirety, and a hearing on that motion is scheduled for March. Now, guys, I'm gonna sound like a broken record, but I'm gonna say this anyway. In the original trial, when the jury made the announcement that they couldn't come to a unanimous verdict on any of the charges that Reed was accused of. Why did neither the prosecution nor the defense ask for the jury to be polled on each charge? Why? Because that way it would have given both sides a gauge. It would have given both sides a gauge as to where the jury was leaning, how the jury was leaning, and on what charge the jury was leaning in that particular direction. I mean, you hear it happen on convictions, you hear it happen on acquittals. How come it couldn't have been done for a mistrial declaration? All they have to do is ask each juror as to this count. Is this your verdict? No. Take that back. I take that back slightly. On this count, juror number 1, what is your verdict? On this count, juror number 2, what is your verdict? On and on and on until you hear from all 12 jurors on each count that Karen Reed is accused of. Again, that's the gauge you go by before the judge can ultimately say, okay, I've heard enough. I hereby declare this case a mistrial. Common sense, right? Instead, you have all this craziness. You have all this just to get back to a second trial starting in April. Will this retrial have happened had the attorneys went in the direction I just mentioned? Maybe, maybe not. We'll never know how that would have went then. But April's getting closer and closer. Next up, this is the Donna Adelson update. She's back. She went back to court on the 11th and agrees to hear a bond. The judge agrees to hear a bond request on the 26th. Adelson's lawyers said they have more witnesses to depose, and that at that hearing they announced plans to depose Donna's son, Rob. On the heels of a shocking announcement that Donna Adelson has been placed in protective custody for her own safety, the Florida matriarch appeared in court to address several other matters. This was on last Tuesday. Adelson faces first-degree murder and other charges for her alleged role in the 2014 killing of her former son-in-law, Dan Markle. At Tuesday's hearing, she appeared via Zoom as her defense attorneys informed Judge Stephen Everett that they need to depose several witnesses prior to trial. That list includes Adelson's estranged son, Rob Adelson, an FBI agent, and a TPD officer. Defense attorneys Jackie Fulford and Josh Zellman also notified the judge that they will be filing several motions to suppress evidence in the coming days, and that they will file multiple motions in the mean prior to the trial. Markle, a Florida State University law professor, was gunned down by a hitman in his Tallahassee garage. The victim was the ex-husband of Donna's daughter, Wendy Adelson. Donna and her son, Charlie, allegedly masterminded a plot to have Markle killed. The shooters were already in prison, as is Catherine Magbanua, the woman who acted as a liaison between the Adelsons and the hitman. Charlie was tried and sentenced to life without parole late last year. Donna was apprehended on November 13, 2023, a week after Charlie's conviction, while attempting to travel to Vietnam on a one-way ticket. In addition, Judge Everett has granted Donna's request for a bond hearing. Last week, Donna's attorneys filed a motion based on allegations that the 75-year-old defendant has been subjected to physical abuse, sexual abuse, and extortion while housed at the Leon County Jail. The defense also argued that their client needs medical attention that she cannot get at the jail. The judge will address that request on February 26th. Donna is also seeking a separate hearing to address the defense's request to remove a November 2023 jailhouse phone call from evidence. During the call, Donna spoke to an incarcerated Charlie about fleeing the country or possibly ending her life. Judge Everett also made it clear at Tuesday's hearing that he will not extend any deadlines that have been imposed. May 16th will be the final day to hear any pretrial motions, and trial is on track to commence June 3rd. Again, another one of those cases that has been off the rails since Jump Street. And there's still one other mystery left, no matter what happens with Donna. A, is Wendy Markelson and a coming suspect, and B, will she face charges? All those wanting to wait and see, get ready. All right. I won't do the disturbing exhibits and key players in the Baby Evelyn murder trial, because even that will hurt your heart. We'll get to Baby Evelyn a little bit later. Next up, prosecutors unveil a possible to-do list of the man suspected of murdering his brother a week before the wedding. And one of the items on that to-do list, burn clothes. David Perry was found fatally shot in a warehouse co-owned by his brother, Charles Perry. South Carolina prosecutors want to test the handwriting of a man suspecting of murdering his brother after finding a note resembling a to-do list with instructions, such as burning evidence and removing surveillance camera footage. 51-year-old David Perry was found slain inside of a Charleston, South Carolina warehouse on December 18th, shortly after he was reported missing, according to reporting by the Post and Courier, ABC4, and WCSC. David's fiancée, Alexander Fisher Muller, said during a court appearance on February 6th that he was killed just a week before the couple was set to get married. Again, that's according to a report from WCSC. His brother, 54-year-old Charles Perry, has been arrested and charged with murder in connection with the killing, as well as weapons possession. David was reported missing earlier on December 18th, prompting a welfare check at the warehouse he co-owned with his brother, the outlets reported. During their check, officials found David fatally shot inside the facility, according to North Charleston police. In court Thursday, prosecutors unveiled a note that resembled a to-do list with instructions to burn clothes, switch off security footage, and hide a gun. That's according to reports from the Post and Courier, ABC4, and WCSC. The note also had other words such as unique pants, unique shirt, long sleeve, unique socks, and hammer. That's according to an affidavit that was cited by ABC4. Charles was ordered on Friday to provide handwriting samples for the investigation, according to online case information reviewed by People magazine. The brothers both work for their family's business, Carolina Sound Communications, the website for the company which designs, installs, and services audio, video, and security solutions to meet the needs of commercial clients, did not have Charles's information as of Tuesday. Police have not identified a motive behind the crime. Charles was denied bond at Thursday's hearing. Online court records did not indicate a plea, and People magazine has reached out to an attorney in this case docket for further information. And so basically, we're just waiting on information on this particular case too. And when we get it, you'll be the first ones to hear it right here at Bethea'S Byte Reloaded. And you have my word. No gimmicks, no drama, no BS, just straight up news. Next up, I'm gonna have to put the old trigger warning on for this next story. Stand by for 1 second. There you go. Here's why I have to put the trigger warning on. Teacher sexually abused student with special needs and then asked him to bring a gun to school to shoot a colleague. 28-year-old Emma Jean, I'm hoping I'm pronouncing that name correctly, Emma Jean K. Ewer, was sentenced to 4 years in prison after pleading guilty to sexually assaulting a 16-year-old student in her care. A former Colorado paraprofessional has been sentenced to 4 years in prison after admitting to sexually assaulting a 16-year-old student. In November, Emma Jean K. Ewer pleaded guilty to sexually assaulting a special education student she was assigned to care for at Brady Exploration School in Lakewood, Colorado. That's according to the First Judicial District Attorney's Office. As part of a plea agreement with prosecutors, Ewer pleaded guilty to sexual assault on a child by one in a position of trust and contributing to the delinquency of a minor in the first degree, both of which are felonies. 3 other felony counts and 1 misdemeanor were dismissed in exchange for a guilty plea, the DA said in a statement. On Friday, January 1st, Ewer was sentenced to 4 years in prison, which will be followed by probation in the Sex Offender Intensive Supervision Program for 10 years to life. During the sentencing, the victim's mother addressed the court saying, "The defendant preyed on my son, leading him to believe she genuinely cared for him, all while exploiting him for money and manipulating him into thinking he was the one," according to the statement. "What makes this even more painful is that I trusted the defendant," she said. "Had I known what was truly happening, I would never have allowed her such close access to him." Ewer introduced the victim to fentanyl. That's according to Special Victims Prosecutor Bryn Chase. Ewer also sent victim thousands upon thousands upon thousands of text messages saying that she wanted the victim to bring a gun to their sexual encounters, Chase said in court. Ewer even told the victim to bring the gun to school and shoot another faculty member in the leg, Chase said. The crime came to light in November 2023 when a teacher at the school called police after seeing inappropriate writing on one of the students' worksheets. Police had launched the investigation, which revealed that Ewer's favoritism towards the child was noticed by staff almost immediately, with evidence of an inappropriate relationship beginning in approximately September 2023. Detectives discovered evidence of frequent sexual encounters, constant digital communication, inclusive of repeated derogatory remarks directed at the victim, and the introduction of drugs, alcohol, and weapons, it said. Ewer, who had worked for the Jefferson County Public Schools from 2015 to 2023 as a school nurse, a paraprofessional, and a teaching assistant, was arrested in January 2024. She was charged with sexual assault on a child by someone in a position of trust, sexual exploitation of a child, unlawful electronic sexual communication, and contributing to the delinquency of a minor, online court records show. At the sentencing, Ewer said, "I just want to apologize to the victim and the victim's family. I'm really sorry. This will never happen again." Her attorney did not respond to People Magazine's request for comment. Before I give you my commentary on this story, I have a couple of PSAs to bring to you. First, if you know someone who has been a victim of sexual abuse, you are not alone. There are people out there that is looking to help you. Get on your cell phone and text the crisis text line. Text the word strength, STRENGHT, to the number 741-741. You will be connected to a certified crisis counselor. You do not have to be a statistic. Text strength to 741-741 and get the help you so desperately need. Also, if you or someone you know has been sexually assaulted, don't wait. Don't make yourself a victim. Don't make yourself a statistic. There are people that want to help you out. You're asked to call the National Sexual Assault Hotline. That number is 1-800-656-HOPE. 1-800-656-4673. Or log on to www.rainn.org. You no longer have to be a statistic, or you do not have to see yourself as a perpetual victim of these crimes. Get help now. As far as my commentary on this particular case, you're in a position of trust with those who really don't understand what's going on. You're supposed to be the example for those who are special needs, and you taking advantage of that. You're going to take advantage of that and inflict harm. Get him to bring a weapon to school to shoot a fellow colleague in the leg. You must have something going on in your head. But as far as I'm concerned, there is one thing you said in your apology that I totally agree with. This will never happen again, because I have this feeling you will never see the inside of a schoolhouse again. You may be in jail for 4 years, and then you have to submit yourself into, what was that? Let me see. Yeah, you'll be put after 4 years. You're going to be on probation in the sex offender intensive supervision program for the next 10 years to life. Yeah, this ain't going to happen again. Guaranteed. Justice served, as far as my opinion goes. Okay. Last year I brought you this story about a woman who just went nuts at a grocery store, I believe, and ended up killing a child in a grocery store parking lot. Well, this woman, Bianca Ellis, has been deemed competent to stand trial in the death of Julian Wood. She's facing 10 felony charges. The woman accused of fatally stabbing a 3-year-old in an Ohio grocery store parking lot has been deemed competent to stand trial. Bianca Ellis faces 10 felony charges for the June 3, 2024 homicide. North Olmsted police said the 33-year-old stole knives from a thrift store before walking into the nearby Giant Eagle and using the weapons in a seemingly random attack. 3-year-old Julian Wood died and his mother was injured. The attack has shaken many people in the North Olmsted community. Now it's just a part of my life, pulling in and pulling out. That's what I'm looking at, so he's never going to be forgotten, Mike Zart said, referring to a mural on the side of a building where his contracting business is based. In October, a local artist painted a bright green dinosaur on a building near the grocery store in Julian's honor. It now features a plaque with a dedication from North Olmsted leaders. Zart said the mural attracts frequent attention from many who were touched by the tragedy. It's a daily occurrence. You'll see them taking photos or stopping their car and talking about it. In the 8 months since the attack, the case has garnered outrage and calls for accountability. Questions about the defendant's mental health have also been a central concern. Ellis's attorneys pointed to her strange behavior in court and said her mental state made her unable to participate in her defense. She was previously ruled incompetent to stand trial, and a judge ordered her to receive treatment and take her recommended medication. According to Cuyahoga County Court of Common Pleas records, Ellis was undergoing an evaluation when the doctor treated her stated the defendant is incompetent to stand trial, but there is a substantial probability of restoration to competency within the statutory time frame if provided with a course of treatment. On Tuesday, both prosecutors and defense attorneys agreed the treatment was working and the case could move forward. Competency looks at today. Is she able to do this? Not guilty by reason of insanity looks backward to the time of the crime. Was she capable of controlling and understanding at the time of the crime? So that issue would have to be explored. Case Western Reserve University criminal law professor of practice Michael Benza explained this in July. Attorneys on both sides declined to comment on the ongoing case on Tuesday. Neighbors say they hope the competency ruling is a step toward accountability and justice for Julian's family. It's got to be some consolation for them, if there's any, said Zart. It's never going to replace him or repair what happened. The trial for Bianca Ellis is scheduled to begin July 14th. Guys, this is one of those cases I think long and hard about, and I stand with so many who say Julian Wood deserves justice. No matter how small or great that looks, he deserves justice because he should be alive with his family today. That's all I got for that. We'll wait to see what happens when Bianca Ellis' case picks up. Next up, we have an update on a case I also brought last year. We have a suspect facing a new charge after missing Ole Miss student's body has been found. Sheldon Timothy Harrington is charged with murder and tampering with physical evidence in the death of Jimmy J. Lee III. This is another case that was that ended in a mistrial, but at least this case is a lot more put together than the Karen Reed case. Before they can go into a retrial, the man accused of murdering a missing University of Mississippi student will face an additional charge after the victim's body was found. Sheldon Timothy Harrington Jr. was initially charged with murdering Jimmy J. Lee II, who was last seen alive on July 8, 2022. Harrington's first trial ended in December 2024 with a mistrial, when the jury could not reach a unanimous verdict. A superseding indictment filed on February 11th adds a charge of tampering with physical evidence to the charge of capital murder Harrington faced at the retrial. He was arraigned on the new charge as soon as the indictment was filed on Tuesday. While the judge declared Lee legally dead before Harrington's first trial, his remains were missing until this month. Hunters found Lee's remains in a patch of forest at a well-known dumping site for tires and trash. That's according to the Mississippi Free Press. In a video posted on social media, Lee's father, Jimmy Lee Jr., expressed the family's gratitude and relief after his son's remains were found. We're just so thankful that he's here and we know where he is now, Lee said. Our thought process is justice now. We're hoping and praying that justice will prevail. Prosecutors said at Harrington's first trial that the two had been in a sexual relationship at the time of the murder and suggested Harrington kill the victim to hide his sexual orientation. The victim, a student at the University of Mississippi, was a well-known member of the LGBTQ plus community. So we have to we'll wait and find out exactly what's going to go down when the retrial begins for Sheldon Harrington. Next up, Stephen Stearns is absent from court as his trial is delayed. The judge agreed to postpone Stephen Stearns' trial on sex abuse charges until the spring because the defense has yet to view key evidence. Stephen Stearns is accused of sexually abusing and murdering his girlfriend's young daughter. He was absent from court as his attorney asked for his upcoming trial to be delayed. Stearns was arrested last February after his girlfriend's daughter, 13-year-old Madeline Soto, disappeared. During the investigation into her disappearance, police found more than 1,500 disturbing images and videos going back years, which allegedly included media showing Soto being sexually abused. Stearns was charged with 60 counts related to sexual abuse of a minor and child pornography. Days later, when Madeline Soto's body was found, he was also charged with her murder. After his arrest, Stearns immediately waived his appearance at all pretrial hearings and has not been seen in court for any hearing in either of his cases. Oh, goodness, excuse me. Wednesday was scheduled to be Stearns' final pretrial hearing ahead of his trial for sex charges, which had been scheduled to begin on February 24th. Judge Keith Karsten, noting how long the case has stretched on, agreed to postpone the trial in the spring because the defense has not had access to key evidence in the case. Assistant State Attorney Danielle Pennell told Judge Karsten that the defense has not been able to view the images and video at the center of the sex crimes case. Evidence that can only be viewed at the prosecutor's office because of the sensitive nature of what it contains. That appointment is currently scheduled for next month. Stearns' attorneys have filed 3 motions seeking to suppress evidence seized in the case, accusing police of not following the proper procedures when they took Stearns' cell phone into custody. Alicia Smith, Stearns' attorney, said she did not want to schedule a date for those motions to be heard until she filed a 4th motion seeking to close the courtroom. Stearns faces a potential death sentence if he is convicted in his murder trial, which is set to begin on September 22nd. His sex crimes trial is now scheduled to begin May 5th. And this guy, this is one guy that really, really tops it for me. Who does what he's accused of and thinks on top of it he's getting away with it. May 5th, he's got to face those charges. Then there's his September trial, where he's got to face that charge of murdering Maddie Soto. And I still believe, to my heart to this day, that excuse me, guys. I may be a little bit out of it for some of these cases, but I still got something. I still got something to say. If there is one other person I believe that should be charged was literally sitting back and doing absolutely nothing. It's Jennifer Soto. And I will say that until the end of that trial, because literally, what did she do? She sat back and did nothing. She either just allowed it to happen, or she was just scared of Sicko Stearns. Shout out to Court TV's Julie Grant for the name, Sicko Stearns. I'm gonna keep an eye out on this case, and hopefully we'll get some resolution and hopefully justice for Maddie Soto. The father of accused Georgia school shooter has been granted bond. A judge granted Colin Gray a $500,000 bond as he awaits trial on 29 charges, including second-degree murder and involuntary manslaughter. This is basically following the same pattern as we had with the Crumblies. In a rare case of a parent being charged after a school shooting, a judge granted a $500,000 bond for the father of a 14-year-old boy accused of a deadly attack at a North Georgia high school. Colin Gray has pleaded not guilty to 29 counts, including 2 counts of second-degree murder and 2 counts of involuntary manslaughter in connection with the September 4th mass shooting at Appalachian High School in Winder. 54-year-old Gray and his son, Colt Gray, were both indicted in the shooting that killed 2 students and 2 teachers and injured several others. Both have pleaded innocent to the charges they face. Colin Gray had given his son the assault-style weapon as a Christmas gift and was aware that the child's mental health had deteriorated in the weeks before the shooting. Investigators testified at an earlier hearing the father was also aware that his son was obsessed with school shooters and even had a shrine above his home computer for the gunman in the 2018 Parkland, Florida school massacre. And that's according to Florida prosecutors. At the hearing, several relatives of the dead and injured spoke, with some breaking down in tears as they described the loss of their loved one. They pleaded for the father to remain jailed without bond as he awaits trial. I feel that the sheer irresponsibility of Mr. Gray as a parent robbed my family of the chance to raise my son, Brianna Shimmerhorn, whose 14-year-old son Mason was killed in the attack. What you, the families, are going through, what the community is going through, is undeniable pain, and I understand that, Judge Nick Prim said. This case is an open sore. It's a wound that continues to hurt the community, he added. Colin Gray's lawyer, Jimmy Berry, said the state has not proven that the father would pose any threat if released on bond. The purpose of the pretrial bond is not to punish him before his conviction, Berry said. The judge said he is constrained by the law, and in deciding bond, Gray is presumed innocent, and the law does not permit me to be emotional, he said. Georgia law in bond cases involves weighing whether there's a risk that Gray would flee, whether he would pose a danger to the community, and whether he would try to influence or threaten witnesses. There's been no evidence that any of that would occur if bond were to be granted, the judge said. Gray was ordered to have no contact with witnesses. If he's unable to post the money, then he will remain jailed. The judge says he does not believe Gray could return to Winder, a small town northeast of Atlanta, while awaiting trial. In the court of public opinion, he bears a scarlet letter, he said. Before Prim issued his ruling, Colin Gray testified that if bond were granted, he would live with his sister in Cherokee County, about 70 miles from Winder. Colt Gray is charged as an adult and indicted on 55 counts, including murder, and 25 counts of aggravated assault at the high school. His father faces 29 charges, including 2 counts of second-degree murder and 2 counts of involuntary manslaughter. Both also face multiple counts of cruelty to children. The shooting killed teachers 39-year-old Richard Aspinwall and 53-year-old Christina Irami, and students Mason Shimmerhorn and Christina Angulo, both 14. Another teacher and 8 more students were wounded, 7 of them hit by gunfire. Colin Gray is the first adult known to be charged in a school shooting in Georgia. His indictment is the latest example of prosecutors holding parents responsible for their children's actions in school shootings. Michigan parents Jennifer and James Crumbly, the first to be convicted in a U.S. mass shooting, were sentenced to at least 10 years in prison for not securing a firearm at home and acting indifferently to signs of their son's deteriorating mental health before he killed 4 students in 2021. Investigators have said Colt Gray carried a semi-automatic assault-style rifle onto a school bus, with the barrel sticking out of his book bag, wrapped up in a poster board. They say the boy carefully plotted the shooting at the 1900 student high school northeast of Atlanta, drawing diagrams and listing potential body counts in a notebook. He left his second period class and emerged from a bathroom with the rifle before shooting people in a classroom and hallways. 1. I totally disagree that he should have any kind of bond at all. There, I said that. 2nd, I totally agree that he should bear some of that responsibility too. For everything that he's being charged with, he might as well have been the one to pull the trigger. Because 1, you gave it to him for his 19th, for his birthday. You gave it to him for his birthday. Number 2, how could you not notice his mental health deteriorating? I'm asking Colin Gray the same question I asked of James and Jennifer Crumbly. Oh, but the difference is they noticed it, they just ignored it. And if Colin Gray did the same thing, he deserves the time that he's gonna end up getting. Next up, Aaron Stratman, given a $25,000 secured bond as she awaits trial on charges that she abused an infant at the hospital where she worked. All right. 25-year-old Aaron Stratman, a nurse charged with abusing a baby in the neonatal intensive care unit at Henrico Doctors Hospital, granted a $25,000 secured bond in Henrico Court. The judge placed several conditions on Stratman's bond, including that she must wear a GPS monitor, she must stay at her parents' house, she may not provide services as a healthcare professional, she may not be in the presence of minors or vulnerable adults, she may not use illegal drugs or drugs for which she doesn't have a prescription, she may not have contact with the individual she's named on social media as her boyfriend, and she may not have firearms in her residence. The judge granted Stratman bond after she underwent a mental health evaluation. The results of the evaluation were sealed after they were presented in court. The Commonwealth maintained the position that we were objecting to any conditions of release, Enrico Commonwealth attorney Shannon Taylor said outside of court. We believe the actions were so egregious and the strength of the Commonwealth's case is so strong that we did not believe that there were any conditions to ensure safety to herself or the safety to others. The court, of course, is our neutral arbitrator and has the law, and he has very purposely in going through the factors. We understand why the court said what he said. We just, of course, were advocating for our position that we believe that she should be held. Stratman's attorney said they were pleased with the judge's decision to grant bond, while family members of injured babies told Script News Richmond reporter Melissa Hippolyte that they were disappointed. I think we share the same feeling of anger, Dominique Hackey, whose son was injured in the NICU at Enrico's Doctors Hospital. This is something that we were prepared for, but obviously we didn't expect. We definitely didn't feel like Richmond is safer with her out on the streets. Now she's out on the street celebrating with her family when she's done something so despicable. I don't understand it. I don't understand it. While Stratman is not charged with injuring Hackey's son, he did speak with a family member of the child whose injuries led to Stratman's arrest. She wants to share that she's angry, Hackey said. Ever since the story came out, all that we wanted to do was protect our children. We don't feel safe with her on the street. Nobody should feel safe. He pointed out that while she was on paid administrative leave, Stratman contacted multiple families to ask if she could take care of their children. Obviously, this woman has a compulsion, Hackey said. Just because she doesn't have prior convictions, she's allowed to roam the streets or to roam her hallways in her house. But still, it's a privilege that she doesn't deserve. Enrico Doctors Hospital forced Stratman to take paid administrative leave in September 2023 after an internal investigation into fractures suffered by 4 infants in the NICU. Child Protective Services and Enrico Police investigated the 2023 cases, and CPS determined the infants had been abused but found there was not sufficient evidence to say that Stratman was responsible. The hospitals brought Stratman back to work in September 2024. Several weeks later, 3 more babies suffered mysterious broken bones in the NICU. Investigators said Stratman was caught on camera abusing one of those infants in November 2024. She was arrested in January 2025 and charged with malicious wounding and child abuse. She remained in jail following her arrest, where her mental health was evaluated before bond was granted on February 12th. Another one that does not deserve any kind of bond but got one anyway. And like the families of the victims are saying, they're suffering, yet she's allowed to celebrate with her family. That is a privilege she does not deserve. And note, I said privilege, not right. Meanwhile, these families are going to continue to suffer until the victims of those families get justice. No one, I don't care if it's a special needs adult or a child, a defenseless one at that, deserves to be abused. And now it's time for another update in Did He Do It? In this update, Sean Diddy Combs is suing NBC over the new documentary as he awaits trial. Combs is suing NBC Universal over a documentary he claims accuses him of being a serial murderer who had sex with underage girls. I would have played the NBC tones, but like I said, no gimmicks. Sean Diddy Combs is suing NBC Universal over a documentary that says falsely accuses him of being a serial murderer who had sex with underage girls as he awaits trial on federal sex trafficking charges. The lawsuit filed Wednesday in a New York state court says the documentary, Diddy, Making of a Bad Boy, included statements that NBC Universal either knew were false or published with reckless disregard for the truth in order to defame the founder of Bad Boy Records. Indeed, the entire premise of the documentary assumes that Mr. Combs has committed numerous heinous crimes, including serial murder, rape of minors, and sex trafficking of minors, and attempts to crudely psychologize him, the complaint reads. It maliciously and baselessly jumps to the conclusion that Mr. Combs is a monster and an embodiment of Lucifer with a lot of similarities to Jeffrey Epstein. Spokespersons for NBC Universal and the entertainment company that produced the documentary, which is also named in the suit, didn't immediately respond to details seeking comment. The documentary premiered last month on Peacock TV, the network's streaming service. From his childhood to becoming a mogul, this raw look at Sean Combs' journey through exclusive footage and candid interviews explores his rise, controversies, and the man behind the music, a description of the documentary on Peacock's website reads. Combs is seeking no less than $100 million in damages, has been in a Brooklyn federal jail since his September arrest on racketeering, conspiracy, and sex trafficking charges. Federal prosecutors say he used his wealth and influence to coerce female victims and male sex workers into drug-fueled, days-long sexual performances known as freak-offs. They say Combs used blackmail and violence to intimidate and threaten his victims in a pattern of abuse that goes all the way back to the early 2000s. Combs has pleaded not guilty and his trial is slated to start in May. In the criminal case on Wednesday, a federal judge rejected a request by Combs' lawyers that a hearing be conducted over 19 pages of Combs' notes that were taken from his cell during a Bureau of Prisons sweep of the Metropolitan Detention Center in Brooklyn, where Combs is being held without bail. Defense lawyers say the seizure violated Combs' constitutional rights, but Judge Aaron Subranian said in a written opinion that a review shows the government did not intentionally invade Combs' attorney-client privilege. The appropriate steps were taken afterward, and the issue is moot because prosecutors say they will not use any of the information at trial. In the civil lawsuit Wednesday, Erica Wolf, an attorney for Combs, said NBC and the other entities named in the suit maliciously and recklessly broadcast outrageous lies in order to line their own pockets by driving viewership to the documentary. In making and broadcasting these falsehoods, among others, defendants seek only to capitalize on the public's appetite for scandal without any regard for the truth and at the expense of Mr. Combs' right to a fair trial, she said in a statement. Mr. Combs brings this lawsuit to hold defendants accountable for their extraordinary damage that their reckless statements have caused. Combs' lawsuits say the documentary falsely, recklessly, and maliciously accuses him of murdering Kimberly Porter, Christopher Wallace, and Dwight Arrington Myers, among notable names. Porter, a model who had been Combs' longtime girlfriend and the mother of some of his children, died in 2008 at the age of 47 from complications from pneumonia. Wallace, the rapper known as the Notorious B.I.G., was killed in 1997 in a still unsolved drive-by shooting in Los Angeles at the age of 24. Myers, the rapper known as Heavy D, died from a pulmonary embolism in 2011 at the age of 44. It shamelessly advances conspiracy theories that lack any foundation in reality, repeatedly insinuating that Mr. Combs is a serial killer because it cannot be a coincidence that multiple people in Mr. Combs' orbit have died, the complaint reads. Elsewhere, the complaint says the documentary delved into claims Combs had sex with underage girls, citing as evidence a civil complaint that's been thoroughly discredited. Combs' lawyers say the women referenced in that complaint have since confirmed they were adults at the time. First of all, I want to go ahead and eliminate those three murder claims that the documentary is using against Diddy, and I can't confirm that all these dates and passings of Kimberly Porter, of the Notorious B.I.G., and of Heavy D. When the news broke of those three deaths, it kind of shattered a lot of us in the hip hop community. So those claims from the Peacock documentary as false. So maybe he has a shot to win this thing here. We'll just have to wait and see what happens next. So until then, stay tuned for another episode of Did He Do It? Now, an exclusive interview with People Magazine. Elizabeth Holmes defends having two babies on her path to prison, stating, "I know how the optics look." The disgraced Theranos founder opens up in a prison interview about giving birth to two babies during her fraud trial. For 2 years, Elizabeth Holmes has been in a Texas prison while her children, 3-year-old son William and 2-year-old daughter Invicta, are being raised nearby by their father and Holmes' partner, Billy Evans. The disgraced founder of blood testing company Theranos, who turned herself in on May 30th, 2023, began serving her 11 and a quarter year prison sentence. Holmes delayed her fraud trial and sentencing since both of her pregnancies coincided with her criminal prosecution in 2021 and 2022. Critics have long accused her of using her status as a mother to avoid jail time and gain sympathy. But in her first interview from prison, Holmes insists to people that parenthood wasn't a ploy. "I know how the optics look, but I always wanted to be a mother," she says as she sits in a blue plastic chair inside federal prison camp in Bryan, Texas, her home for the next 7 years. "I wanted to have children, be a mom. I truly did not think I would ever be convicted or found guilty. I kept talking to my lawyers, and they also assured me we would never get this far. It wasn't planned, and I can't worry about what others think," adds Holmes, whose children will be 10 and 9 years old when she's slated for release in 2032. Her sentence has been reduced by 2 years for good conduct. It's just when the timing happened. This is Elizabeth Holmes here, and this is the exclusive interview, Her Life Behind Bars. Holmes, who dropped out of Stanford University to create Theranos at age 19, built the company to a $9 billion valuation and became the world's youngest self-made female billionaire. But her rise to fame ended in disgrace after it was revealed that her company's much-hyped blood testing technology produced inaccurate results. In 2018, she and Ramesh Sunny Balwani, her one-time business and romantic partner, were indicted after misrepresenting the capabilities of their devices to investors. Both had pleaded not guilty. Holmes' trial, which had already been delayed 3 times due to the COVID-19 pandemic in 2020, was pushed back again when her legal team requested a delay due to her first pregnancy. Assistant U.S. Attorney Robert Leach, who was prosecuting the case, said it was frustrating and disappointing to learn of the delay at that point. While 8 months pregnant, Holmes attended a pre-trial conference on June 15, 2021. At the time, U.S. District Judge Edward Davila said he'd provide a quiet room for Holmes and the baby she was expecting during breaks in the trial. A month later, she welcomed her first child, William, also known as Wills, just weeks before her fraud trial began. Holmes had met Evans, a hotel chain heir, at a rooftop charity event in October 2017, and he proposed a year later in August 2018. Together they decided to start a family despite the legal jeopardy that Holmes was soon to face. I asked him 20 times if he wanted to spend his life with me, Holmes recalls. There were a million reasons why not. Holmes was tried on 11 counts of fraud and found guilty of 4 of the charges. 3 counts of wire fraud and 1 count of conspiracy to commit wire fraud. Convicted in January 22, and with her sentencing scheduled for November, Holmes revealed that she was pregnant with a daughter whom she would name Invicta, Latin for invincible. In a letter to the sentencing judge obtained by People magazine, Evans spoke about how Holmes' trial had impacted their lives and asked for a lighter sentence, saying his fiancée would miss out on milestone moments. My heart is broken with the thought of spending any days away from Liz, for a future in which my son grows up with a relationship with his mother on the other side of glass, armed by guards. The letter read, The gravity of time without her is hard for me to comprehend. Holmes' defense team cited her 2 very young children in its argument in February 2023 for why she was not a flight risk and should remain out of prison while she appealed her fraud conviction, which was denied. She was scheduled to begin serving her sentence on April 27, 2023, but it was pushed back a month when she gave birth to her daughter. When Holmes was finally driven up the prison gates in a Ford expedition in May, she was using a high-tech breast pump to collect milk for then 3-month-old Ivy. Upon surrendering, she explained to guards that she was still breastfeeding her daughter and was then allowed to have 2 pumps with her. I wanted my daughter to have her mother's milk, she said. It was important to me because it was a way to love her in here. Looking back, Holmes says, I received a considerable amount of time I wasn't expecting. I always wanted a big family. Billy wanted even more kids. It was such a beautiful experience and such a horrible time, she adds. It pains me that I am behind bars and I am not there for all the moments that matter in their life. People can think what they like about me, but it just happened, and it's the happiest moments in my life. I love them. For more on Elizabeth Holmes and her prison life and her children, if you want to get all that information, pick up the new issue of People magazine, which is on newsstands right now. Next up. Let me make sure. Yeah, I do have the trigger warning up. Okay, next up. A man strangles his mother to death with a cord because he's angry she's dating. Norma J. Carricker, age 60, killed by her son Neil Howard in September of 2023. Here's Mom Norma and here's Neil. Alright, let's file this under justice served. An Illinois man has been convicted of first-degree murder for killing his mother in September of 2023. Norma J. Carricker's son, 46-year-old Neil Howard, killed her in her Troy, Illinois home because he did not approve of her dating, according to a statement from the Madison County, Illinois State's Attorney's Office. He strangled his 60-year-old mother on September 13, 2023, shortly after she went on a date, the statement said. Howard wrapped that cord around her neck and pulled until she stopped breathing, Assistant State's Attorney Luke Yeager told jurors during the week-long trial. Yeager presented evidence showing Howard's resentment over his mother's dating life. This defendant has had enough of his mother, he told jurors. This is according to a report from the Belleville News-Democrat. Yeager said Howard was angry about his mother dating and not giving him money. Howard got angrier and angrier and angrier until he got drunk enough that he couldn't take it anymore, Yeager said per the state attorney's statement. Carricker was a former waitress and the widow of the ex-mayor of Troy, according to her obituary. Norma never met a stranger, loved and took care of many family and friends, part of the obituary reads. Several well-wishers left notes in the obituary, including customers she waited on. One customer said Carricker helped them raise funds for multiple sclerosis research with her tips. Howard's defense attorney, David Fahrenkamp, told the News-Democrat that there would be an appeal. I don't argue things that I don't believe in, he said, per the outlet. I believe in this case, I believe in Neil. The defense argued that there wasn't enough focus on other possible suspects, the News-Democrat reported. The jury returned its verdict, and it's guilty, a spokesperson for the state's attorney office telling People magazine in response to the defense's claim. One of Howard's sisters testified in his support. Other family members, including his other sister, were reportedly seated behind prosecutors in court. Howard is scheduled to be sentenced at an unspecified time later and faces up to 60 years in prison, according to the state attorney's office. You're mad your mother is dating. You're mad your mother is not giving you any money. So you got angrier and angrier and angrier and angrier until you decided enough is enough, and you want to take it all out on your mother in one blow. You take a cord, you wrap it around her neck, and you pull and you squeeze and squeeze until your mother stops breathing. Nice job, son. You killed your mother for what? You're not getting any money? She was dating? You didn't approve of it? Let me get my mic close enough so you can hear these next couple of words that'll come out of my mouth. Too bad. Your mother's a grown woman. She do what she want. Well, at least she did, until you took that away from her. Now, so your mother was 60, right? You were tried, you were convicted, and now you're possibly facing 60 years. I hope you get all 60. I hope you get all 60 without parole. If you live long enough, great. You'll be out by 101 if you make it that long. If not, then it still adds up the same way. Justice served. Norma J. Carricker gets justice. Okay. Now, I mentioned this earlier. Megan Boswell, accused of multiple charges in the death of baby Evelyn Boswell, including first-degree murder. We are going to go right into the courtroom right now, and you are going to hear the verdict and possible, or likely, a possible sentencing recommendation in this trial.
Ms. Boswell, in count one, the jury of your peers having set your punishment, you'll be sentenced to life imprisonment. In count two, you'll be sentenced to life imprisonment. In count three, you'll be sentenced to life imprisonment. We'll have to set this for sentencing hearing where we'll deal with merger, other issues, as well as sentencing in counts 4 through 20. Does she waive the 45 days, Mr. Scott?
She does.
Sentencing in this case for May the 8th.
Judge, that is not good for me. I have a murder trial in Carter County the very next month.
It's not good.
May the 16th.
I expect the Carter County murder trial. We've got 2 weeks blocked off.
May the 23rd.
Yes, sir, I'll be here.
Sentencing will be held May 23rd. Pre-sentence report needs to be filed no later than April the 15th.
Judge, you have May the 22nd instead of the 23rd.
I do.
We'll use that instead.
We can.
Thank you.
That good with the state?
Yes, Judge.
All right. May 22nd. We'll say at 1:30.
Yes.
At 1:30 p.m. Report by the Department of Corrections be filed no later than April the 15th.
Yes, sir.
All right. Anything else we need to take up?
Nothing else for the state.
Mr. Horn?
Yes, Judge. I think from this point going forward, since Mr. Scotland's primary counsel in this case, I would make an oral motion to be relieved as co-counsel on behalf of Megan Boswell going forward.
You'll be relieved. You were appearing as co-counsel pro bono.
Yes, Your Honor.
The court thanks you for your service.
I appreciate the opportunity. Thank you.
All right. Court will be recessed till Tuesday at 8:30 a.m. for the next trial.
Thank you, Judge.
Court stands in recess.
And there you have it. Given the opportunity for parole, Megan Boswell, who was convicted in the death of her little baby, Evelyn, the jury had to weigh whether or not she should get the opportunity after 51 years to be eligible to go before the parole board, and they have agreed with the defense argument that she should be extended grace and love, something that she didn't get throughout her life. Prosecution, of course, said that she didn't give that kind of love or compassion to baby Evelyn, but the jury siding with the defense on this and allowing that sentence of life with the opportunity for parole.
Because the theme going on in my church this year, as far as my pastor's sermons goes to the term grace, God's unmerited favor. Now, I give the prosecutor a lot of credit with this argument. The defense wants grace given to Megan Boswell. But where was the grace given to baby Evelyn? That child was murdered and left in a trash can. Where was that grace? According to the trial update, again, the jury recommends that Megan be sentenced to life in prison with the possibility of parole after 51 years. The sentencing will be scheduled for May 22nd. The jury has convicted Boswell on all 19 charges, including first-degree murder. I'm going to take you to the verdict in that trial before we go any further with this.
Guilty of first-degree murder and the perpetration of a felony. It's the judgment of this court, you are guilty. In count 3, a jury of your peers having found you guilty of first-degree murder and the perpetration of a felony. It's the judgment of this court, you are guilty. In count 4, a judgment of your peers having found you guilty of aggravated child abuse. It's the judgment of the court, you are guilty. In count 5, a jury of your peers having found you guilty of aggravated child neglect. It's the judgment of the court, you are guilty. In count 6, the jury of your peers having found you guilty of tampering with evidence. It's the judgment of the court, you are guilty. In count 7, a jury of your peers having found you guilty of false report. It's the judgment of the court, you are guilty. In count 8, a jury of your peers having found you guilty of false report. It's the judgment of the court, you are guilty. In count 9, a jury of your peers having found you guilty of false report. It's the judgment of the court, you are guilty. In count 10, a jury of your peers having found you guilty of false report. It's the judgment of the court, you are guilty. In count 11, a jury of your peers having found you guilty of false report. It's the judgment of the court, you are guilty. In count 12, a jury of your peers having found you guilty of false report. It's the judgment of the court, you are guilty. Count 13, a jury of your peers having found you guilty of false report. It's the judgment of the court, you are guilty. Count 14, a jury of your peers having found you guilty of false report. It's the judgment of the court, you are guilty. In count 15, a jury of your peers having found you guilty of false report. It's the judgment of the court, you are guilty. In count 16, a jury of your peers having found you guilty of false report. It's the judgment of the court, you are guilty. In count 17, a jury of your peers having found you guilty of false report. It's the judgment of the court, you are guilty. In count 19, a jury of your peers having found you guilty of abuse of a corpse. It's the judgment of the court, you are guilty. And in count 20, a jury of your peers having found you guilty of failure to report a death under suspicious, unusual, or unnatural circumstances. It's the judgment of the court, you are guilty. In counts 4 through 20, the jury did not assess a fine, so there'll be no fine assessed in those counts. Now we'll be in recess about 15 minutes.
Thank you. Court stands in recess.
Guilty on all counts. That is the verdict from the jury in the case against defendant Megan Boswell. She murdered her beautiful 15-month-old daughter, Evelyn. And she put Evelyn's body in a trash can. And there she is crying as she's being led out by a sheriff's deputy to go to the holding area in the courthouse where she will be held It's like a little jail, a little mini jail is kind of what they look like in courthouses, where all of the prisoners will go and be held while they have their cases before the court. So the judge is taking a quick recess with the jury. They'll be brought back in, and then the sentencing phase will begin. And in this case, because the jury found Megan Boswell guilty of the crime of first-degree murder, they get to make a recommendation. So she's going to do life in prison. That's for certain. The jury gets to recommend whether it is with or without parole. That's what the law in Tennessee says. So we're going to proceed immediately to this second phase of the case. Megan Boswell, now a convicted killer. And today, very swiftly, she will learn her punishment for the murder of baby Evelyn.
Convicted of 19 charges. Now, Megan Boswell will have to wait till May 22nd to find out whether she will do the rest of her life behind bars with the possibility of parole after 51 years. That's the recommendation by the jury. We'll find that out. We'll find that out, and I'll be sure to bring that sentencing to you right here. Next up, a Karen Reed update. This one lets us know that Michael Proctor sent inappropriate text after the mistrial. The lead investigator in the Karen Reed case, who was removed from duty over damning text, allegedly sent another profane text a few hours after a mistrial was declared. At last summer's trial, Michael Proctor admitted under oath to sending text to colleagues referring to Reed as, quote, a whack job, a, quote, nutbag with, quote, no ass. According to a new motion filed by Reed's defense team at 5:48 p.m. on July 1st, 2024, the day Reed's first trial ended with a hung jury, Proctor sent Assistant District Attorney Adam Lally, a text that read, yeah, didn't watch Expletive Jackson's closing for good reason. Like all of us, the anticipation and anxiety of the verdict has us all on edge. The Jackson Proctor was referring to is Reed's defense attorney, Alan Jackson. The defense's motion asserts that Proctor's message to Lally is an example of impeachment evidence that can be used to discredit a witness. Other text messages sent by Proctor that came to light at last year's trial include, no nudes so far, end quote, quote, hopefully she kills herself, and comments about her leaky balloon knot. The last text was a reference to an inflammatory bowel disease that Reed suffers from. Proctor, who read those messages aloud on cross-examination, conceded that they were unprofessional and inappropriate. Proctor, who's been suspended from the Massachusetts State Police without pay since July, is awaiting disciplinary action over allegations of misconduct. He's set to appear before the State Parole Board for the third time on March 13th, according to a report from CBS News. That hearing will be a continuance of a hearing Proctor attended last Monday, February 10th. Reed was also in court last Monday when she lost a bid for the court to drop the charges against her, which include second-degree murder. Reed is accused of hitting her boyfriend, John O'Keefe, with her SUV after a night of drinking and leaving him to die in a blizzard. O'Keefe was found dead by the curb outside a fellow Boston police officer's Canton, Massachusetts home. Reed's defense maintains she's being framed. The retrial is on track to begin April 1st. As far as those text messages, that was just wrong, out of line, and unprofessional. And if it were up to me, Michael Proctor, you'd be fired. And that's all I got to say about that. We have another new trial that just got started. It's the wife and lover double murder trial, Arizona versus Kimberly LeCount. Prosecutors are seeking the death penalty for Kimberly LeCount, who is accused of plotting the murder of her wife and in-laws. An Arizona woman faces a potential death sentence if she's convicted of plotting the murders of her wife and in-laws. Kimberly Marie LeCount is charged with 2 counts of murder for the deaths of her wife Alice Kuhn and mother-in-law Peggy Kuhn, who were both shot to death on the family's property. Alice's father, Robert Kuhn, was also shot but survived his injuries. LeCount was also home at the time of the murders, along with the couple's 2 minor children. But prosecutors say LeCount was the mastermind behind the violent scene. At the time of the murders, Alice and LeCount were living with Alice's parents in Glendale. On June 6, 2016, a gunman approached Alice and LeCount while the women were sitting in a Jeep parked on the family's property and shot Alice in the head, killing her. The gunman then went into the family home and shot Peggy and Robert in the head, killing Peggy. Investigators quickly zeroed in on the gunman, Kipling Harris, who had been having an affair with LeCount for several months. Texts between the two allegedly revealed that LeCount had been coordinating with Harris, including mentions of finding a key to a safe with an old revolver and saying she had a plan worked out to the finest detail. Prosecutors say on the day of the murders, LeCount arranged for her adult son to drive Harris to the Coons property and act as the getaway driver after the shooting. LeCount's son, who cooperated with police and denied knowledge of the plan, was not charged. Harris was convicted by a jury on charges of murder, attempted murder, and burglary and was sentenced to life in prison on June 14, 2023. In court documents, police say that LeCount admitted she had solicited several other men over the years to kill Alice, but no one would carry it out until Kipling came along, and said that she provided the weapon used in the murders from her father-in-law's gun safe. Prosecutors have filed a motion seeking the death penalty if LeCount is convicted. The trial has just started with opening statements from both the state and the defense. And then the first witness was the responding officer describing the scene of the crime. He recalls finding Alice Kuhn dead in a Jeep and recalls plotting to force his way into the LeCount home. If she admitted all this, why is she wasting everybody's time to plead not guilty? All that confession plus the evidence that's going to be presented over the next however long, it's going to go against her. It's going to lead to a guilty verdict. And if the prosecution has their way, it's going to lead to a death sentence. Normally, I'm not usually one campaigning for a plea deal. But if I were Kimberly LeCount, knowing what's coming, I'd opt for a plea deal. I'd say, okay, I did it. I planned it all. Put me in prison. Let me go to prison for life. Just take the death penalty off the table. because this evidence is going to come right back to bite her. Next up, the prosecution is fighting to have Sidney Powell's conviction reinstated. They wanted the decision. They warned the decision could serve as a vehicle to entirely rewrite the order of trials throughout the state of Ohio. Prosecutors